I turn now to my good friend, the chairman of the Court Subcommittee, Hank Johnson of Georgia.
Thank you, Mr. Chairman, for holding this very important hearing. Thank you, panelists, for bearing through it. Before I ask a few questions, I'd like to respectfully remind my colleagues that the WikiLeaks organization and Mr. Julian Assange are publishers. Now, if it can be shown that they in some way aided and abetted in the perpetration of or commission of a crime, or if they were parties to a crime, then they could be subject to prosecution. But the Justice Department has yet to come forward with an indictment, and until and unless an indictment is issued, then and until there is a trial on an indictment, then Mr. Assange is entitled to a presumption of innocence by law, and his guilt would have to be proved by there would have to be proof beyond a reasonable doubt before that cloak of innocence, that presumption of innocence, could be removed from him. So first, I would like to just settle us down and let us look at this situation through that lens. We do have constitutional rights, among which is a right to speak freely and a right to publish, First Amendment. And I'd also like to point out the fact that all of the documents that were made available to WikiLeaks are not all classified. Some are classified, and but there have been indications from Secretary Robert Gates that the releases thus far have not significantly harmed overall U.S. interests. And a quote from Secretary Gates is as follows: "The fact is, governments deal with the United States because it is in their interest, not because they like us, not because they trust us, and not because they think we can keep secrets." And so, while there is a public furor about the release of the documents and the information contained therein having been disclosed to the public, we must not get carried away in a fervor as to what has actually occurred. Now, if these leaks, and I assume that they do, undermine national security and the ability of American diplomats to do their jobs, and American personnel who actually engage in compromising this classified information should be prosecuted. It should be prosecuted to the fullest extent of the law. But unless those criminal allegations are proven, let's be careful, and let's insist on that presumption of innocence. Now, the New York Times is also publishing this information, and we aren't shutting down their website or encouraging an international manhunt for its editors. And we cannot allow whatever outrage that we may have, whether or not it be justified or not, to cloud our judgment about our fundamental right to a freedom of the press. And, you know, now we've got to acknowledge that more than just the publishing of this material, this is actually a failure of the U.S. to protect its material. After all, it's a private first class who is alleged to have had access to this treasure trove of information and the ability to download it. Primarily, it's our fault that this information was released, and we need to, and if there is a service or if there is a positive twist on what has occurred, it is that we've been made aware of a softness in our protection of our important information, and therefore we now, because of public disclosure, we're now in a position to correct and make safer and more fail-proof our information. So for that, I would have to thank Mr. Assange for that public service. Now, we certainly should do a better job of protection instead of embarking upon a crusade to harass and even prosecute publishers of information. And I trust that our Justice Department will look very carefully at this case and the chilling effect that a prosecution that is unwarranted could have on our ability to enjoy our First Amendment freedoms in this country. The administration has directed federal agencies to prohibit their employees from accessing WikiLeaks documents on their work computers. It has also been reported that a State Department employee and alumnus of Columbia University School of International and Public Affairs has warned school officials that students interested in a diplomatic career should not access the documents, even from their home computers. If I may ask Mr. Blanton and Mr. Nader, what are your thoughts about this? And censorship-free internet access has been a priority for us as we have dealt with other countries, particularly China. And we encourage them to open up to have free internet or freedom of internet access. And do you see where our current stance could place us in an untenable position as far as assuming a moral high ground for making those kinds of arguments to those around the world who don't enjoy the same freedom as we do? Mr. Blanton and then Mr. Nader.
Mr. Congressman, that wonderful example from Columbia University, I think the best answer to that came from a professor there named Gary Sick, who was a career Navy officer and served on the National Security Council staff under Presidents Ford, Carter, and Reagan. Professor Sick stood up at, I think, an open meeting at Columbia and said, if there's any student of international affairs who is not reading the WikiLeaks cables, then they should be thrown out of the profession, because this is essential information. The Air Force is doing this. This is silly. The Air Force is essentially restricting its own open source information gathering. The Library of Congress is stopping the WikiLeaks site. This is just silly. It's self-defeating. It's foolish. I'm sure it will end. It doesn't get us anywhere. And there's the larger question you're going to, and I think this is where the slippery slope that Mr. Schoenfeld was talking about, he thought the act should apply to foreigners. Well, I have to say, on our website, the National Security Archive, we published the transcripts of Mao Zedong's meetings with Richard Nixon and Henry Kissinger. That's top secret information in China. That would certainly be subject to their Espionage Act. So they get a right to come prosecute me on that basis? I'm sorry, I don't think so. I think we should look at limiting our own laws and trying to move to a different kind of standard about what transparency we can bring about in governments worldwide.
I think those recommendations, Congressman, were, first of all, futile. They can't enforce it. Chilling, and induces not the best type of conscientious civil servant or foreign service officer that these students should aspire to. The second point is on China is very well put. I think Hillary Clinton is not presently recalling her remarks when she, in effect, if anything, lauded the hacksters in China for breaking through Chinese government censorship on the internet. And as you implied, we can't lecture the world in one direction and then start engaging in a kind of suppressive activity in our country. Hillary Clinton would be a very good witness before this committee next year to explain not only what she perceives as the freedom of Chinese hackers compared to other hackers, but also how she has, in effect, done what Secretary Gates has done, which is downplayed the importance in terms of the damage and risk of the release of these State Department cables. The more Gates and Clinton downplay this, it seems the stronger case Julian Assange has for what he's done.
Let me ask if anybody sees any benefit that has accrued from this unauthorized disclosure of documents, of confidential documents, some of which are secret.
I mean, I think, Congressman, I think there are unquestionably benefits, but as Professor Stone mentioned a few moments ago, there's also always harm. Right? I mean, I think that...
Well, and we've talked about the harm. I just want to talk about the benefits.
I take the point, and I think there's, you know, it's hard to dispute that having public access to information that wasn't in the public domain and that should have been is always a positive thing. That, you know, to use the old aphorism, sunshine is the best disinfectant. You know, I don't think the question is whether there's a benefit. I think that seems pretty clear.
Anyone else? Okay.
One quick thing is, this is a benefit. This is a clear benefit from these events because it's allowing Congress to sift through, again, a 100-year-old statute to ensure that it's still working the way it should, is against all the other values that we have. So in that sense, it has sponsored this kind of public discourse, and we are the better for it, I think.
Well, we have some amongst us here in Congress who feel that government is the problem. Government is, as soon as it starts putting its hand in things, then everything goes haywire. So I don't know how we resolve that, that basic conflict, although I guess those folks who would say that the government gets in the way are confining their objections to a commercial context and not a security context. But it is still ironic that there would be those who would chip away at and really hack away at our right to free speech and a free press, while at the same time get government to get out of the regulatory business with respect to commercial activities. So with that, I will yield back. Thank you, Mr. Chairman.
You're welcome, Chairman Johnson.
And would note that not many are around to listen to my comments.
The chair is now pleased to recognize Judge Charles Gonzalez of Texas.
Thank you very much, Mr. Chairman. And Mr. Lowell, thank you very much for characterizing the hearing of the United States Congress as something that's beneficial